Patentable subject matter. 35 U.S.C. Section 101. In Title 35 of United States Code, effective as from March 16, 2013, Section 101 defines patentable inventions as follows. Whoever invents or discovers any new and useful process, machine, manufacture, or composition of matter, or any new and useful improvement thereof, may obtain a patent therefor, subject to the conditions and requirements of this title. In the United States, there are generally two criteria to determine whether the invention qualifies as patentable subject matter. One of the categories. First, the claimed invention must be to one of the four statutory categories as mentioned in Section 101. Section 101 names the four categories of invention deemed to be the appropriate subject matter of a patent. They are processes, machines, manufactures, and compositions of matter, or any new and useful improvement thereof. 4 judicial exceptions. Secondly, the claimed invention also must qualify as patent-eligible subject matter. There are 4 judicial exceptions which are not patent-eligible subject matter. They are abstract ideas, laws of nature, and natural phenomena, and including products of nature. Abstract ideas, laws of nature, and natural phenomena are the basic tools of scientific technological work. Monopolizing these tools by granting patent rights may impede innovation rather than promote it. Exception to the 4 judicial exceptions. The claim must not be directed to a judicial exception unless the claim as a whole includes additional limitation amounting to significantly more than the exception. An invention is not considered to be ineligible for patenting simply because it involves a judicial exception. Therefore, the mere fact that a mathematical equation is required to complete the claimed method and system does not doom the claims to not being patentable subject matter. The integration of an abstract idea, law of nature, or natural phenomenon into a practical application may be eligible for patent protection. Something more additional steps. A distinction must be made between patents that claim the building blocks of human ingenuity and those that integrate the building blocks into something more. The overall process may be patent eligible because of the way the additional steps of the process integrated the equation into the process as a whole. However, simply implementing a mathematical principle on a physical machine, namely a computer, is not a patentable application of that principle. An abstract idea, law of nature, or mathematical formula could not be patented. However, an application of a law of nature or mathematical formula to a known structure or process may well be deserving of patent protection. The Supreme Court, citing Mayo, laid out a framework for determining whether an applicant is seeking to patent a judicial exception itself or a patent-eligible application of the judicial exception, referring to Alice Corporation. This framework is referred to as the Mayo test or the Alice-Mayo test. The first part of the Mayo test is to determine whether the claims are directed to an abstract idea, a law of nature, or a natural phenomena. That is a judicial exception. If the claims are directed to a judicial exception, the second part of the Mayo test is to determine whether the claim recites additional elements that amount to significantly more than the judicial exception. The Supreme Court has described the second part of the test as the search for an inventive concept. The court referred again to Alice Corporation. This all can be found on the United States Patent and Trademark Office website in the MPEP manual. Now, looking at the diagram once again, step 1 is thus, is the claim to a process, machine, manufacture or composition of matter? If no, the claim is not eligible subject matter. If yes, then you go to step 2A. Is the claim directed to a law of nature, a natural phenomenon, a product of nature, or an abstract idea? If no, then the claim qualifies as eligible subject matter. If yes, then you go to step 2B. Does the claim recite additional elements that amount to significantly more than the judicial exception? If yes, the claim qualifies as eligible subject matter. If no, the claim is not eligible to subject matter. Thank you for watching. Please click the subscribe button and give this video a thumbs up.